Conclusion down in Florida. Part of our second Spotlight segment on Long Island this morning. I am talking about the case of Noor Salman, the widow of Pulse nightclub gunman Omar Mateen, found not guilty. Here to talk about it is Brian Wagner. He's a criminal defense attorney, founder of Wagner Law and Associates, based in the city. Also a former senior prosecutor for the DA's office in Brooklyn. First time on the airwaves. We welcome him. Brian, how are you?
Good morning. Happy spring. It looks like spring outside.
Yeah, I'm telling you, unbelievable. But I got to tell you, a lot of people at the Yankee game, I remember in 96, Brian, I went to the Yankees-Royals, was petted on the mound. It was 26 chilly degrees and 8 inches of snow later in the day. So, you know what? A little bit of a taste here.
It happens.
It happens. Very interesting happening down in Florida. That's it's the jury foreman in the conclusion of this trial, Noor Salman, Brian, widow of the Pulse nightclub owner, of course, Omar Mateen, pretty much said jurors were convinced that she knew of the attack beforehand. Interesting statement there. But as he put it, the foreman, no option but to return a verdict of not guilty. Interesting there, huh?
So what that tells me is that jury was paying attention and they were listening to the law that the judge was instructing them on. Because it seems, just based on that statement by the foreman, that they didn't let the emotions of the trial and the allegations get to them, but rather they really analyzed what the facts were and what the law that they were charged with figuring out was. And that's the verdict they came back with. And I think whether we agree or disagree, we have to respect that. And they're the ones that were chosen of all the other people in the world to sit on that case.
Yeah, I mean, pretty much, you get a verdict like this of not guilty. I guess it didn't mean they thought that Noor Salman was unaware of what Mateen was planning to do. Rather that the jury was, maybe not completely tasked with deciding if she was aware of a potential attack, pretty much is what they said.
Yeah, so two things. One, as we all know, it's the prosecution that has the burden. The prosecution has to prove their case beyond a reasonable doubt. So it's not enough that it's just, I think so, which is what, many people think, but that's not what it was. And on top of that, the aiding and abetting that the foreperson talked about, that's the important part. Aiding and abetting means you had to do something, in this case, Noor. She had to do something that actually furthered and assisted her husband in doing this attack. And the prosecution really didn't have any proof of that, is what the jury came back and said. The prosecution didn't prove that beyond a reasonable doubt. And in terms of the obstruction of justice, as we know, because it's pretty prevalent in the news in other cases, what the allegation was that she lied and made up an alibi for her husband when he was being investigated, when in actuality, her husband had lied to her and said, I'm going to dinner with a buddy. And so when she passed that on to the FBI, that's not a lie. That's just having bad information.
Much. Talking with Brian Wagner, the Omar Mateen case. Mateen, who killed 49 people. He wounded, 58 others at the Pulse nightclub in Orlando back in June of 2016 before being killed by police. So, in essence, what we can really kind of ascertain here, Brian Wagner, is, it's interesting. The jury pretty much convinced she did know, but she may not have known what day, location. Those are some key points regarding exactly maybe what she did not know.
Yeah, and that goes back to the aiding and abetting that we talked about. You can know that your husband or wife is a terrible person and that they're going to do something. And even if she knew the exact location and exact time and exact place, that's still not, she's still not guilty of any crime unless and until she does something to assist, further, aid, or induce that act. If she had done any of those things to assist him in pulling out the attack, then she could have been guilty. But in this case, what the jury came back and said is, federal government just didn't prove that. And you certainly didn't prove beyond a reasonable doubt.
talking with defense attorney Brian Wagner, former prosecutor as well, DA's office, Brooklyn. You know, Brian, I look at this situation, and there are plenty of patterns I see regarding the FBI and more faux pas. You know, the jury here acknowledged, yeah, there were several significant inconsistencies as far as the written summaries of Noor's statements, as once again, you got to question the FBI here, why they didn't record his interviews with Noor Salman following the attack, according to what was read. I mean, you would think the FBI would do their due diligence here, and if they would have changed their practices, maybe you might have a different outcome here. But once again, the FBI taking center stage.
Yeah. Anytime that you are not, well, let me go back for a second. NYPD has video interrogation, and that's relatively new, within the last 7 years. And when it first came out, prosecutors were nervous because you're showing how the sausage is made. Interrogations are not pretty. They take hours, and people don't just legally tell the truth. You have to go back after a couple hours, and it's not forced, but you kind of just let time wear down. Investigators are hesitant to show juries that, but when they don't show juries that, they put their own credibility on the line. And that's what happened here. With so many inconsistencies, where the jury came back and said was, how do we believe it? I mean, I don't know if I should believe Agent John or Agent Doe or Agent Schmo. And so it gets back to, how do you believe it, and is it proof beyond reasonable doubt? And in this case, as you said, the jury just said, we can't believe it.
And it's always kind of fascinating to me as far as acquaintances and whatnot, really not knowing. You know, we saw her with the Vegas shooter, Greg Paddock, you know, with his girlfriend who was traveling outside of the country, brought back in for questioning. You know, always kind of baffles me somewhat. But what about Noor Salman really not testifying in her defense? You know, I guess it comes to a point, Brian, you could tell me certainly more than anyone, by putting somebody of her ilk on the stand, it could set up for some incredible ramifications here. I guess if it's not warranted, it won't happen. That's pretty much how it has to come into play. But at what point does an attorney say, you know what, Noor, I think it's time maybe to answer some questions, especially if you feel like maybe the trial's getting away from you? At what point do you maybe think about putting Noor Salman on the stand?
Well, you always prepare to put her on the stand. From the day you meet her, you're preparing her to be on the stand and answer difficult questions. But you don't make the actual decision until the people, the prosecutor, the federal government has said, the people rest. At that point, you take however much time the judge will give you. If that's a day, if that's 5 minutes, and you talk to your client about whether or not it's a good idea. In this case, the defense decided that the people just simply did not prove their case beyond a reasonable doubt, and they have no burden, and they're not going to risk alienating any jurors by having their client get up on the stand. Because that's always the fear. It's not so much that your client is going to tell a story that doesn't make sense, but jurors are smart, and they pick up when someone is telling half-truths or lies, and there's nothing that could turn a jury against you more than if the jury just says, you know what, we might not completely believe the prosecution, but we know we don't believe the defendant. And therefore, even though they're not supposed to, the tie goes to the runner, and the prosecution is going to win out, because when they make their argument, they're going to use every part of the client's statement that corroborates the prosecution's case, and they're going to rip apart every part of the defendant's statement that just simply cannot be true.
You know, I guess it comes down to this, Brian Wagner, you know, circumstantial evidence. You know, what can you say? That's what this case was pretty much based upon entirely, and we know that that type of evidence is only as strong as, you know, the inferences that the prosecution is asking the jury to make. I mean, listen, that's the bottom line here regarding circumstantial evidence.
Yeah, and you're exactly right. It's how strong is the inference. Sometimes circumstantial evidence is better than direct evidence. You know, if you have a grainy video that really shows nothing, then that's direct evidence, but it shows nothing. If you have circumstantial evidence that it has strong inferences, then you say, oh, well, I believe this. And the classic example of circumstantial evidence is you're sitting in a room, and when you came in the room, it wasn't raining. Now your best friend walks in with a dripping wet umbrella and a wet raincoat. Circumstantial evidence suggests it's raining outside. And if you also heard a weather report the day before that it was supposed to rain, as you get more and more supporting facts, that circumstantial evidence can be really strong. But like you said, it all depends on how strong the inferences are.
And especially, Mateen, he was getting the weapon somewhere. He had to spend a ton of money here. Doesn't mean that Noor Salman knew anything about it as far as what he was actually planning to do with those weapons. And the other real faux pas I mentioned prior, was not being videotaped, her interviews, which really kind of, it has to put in the mind of a juror lots of questions here as far as the intention, the credibility, and everything else from the interrogating agent. How do you not at least give some sort of evidence here regarding the answers that she might have given here? You don't have anything to show to a jury.
Yeah, and to me, the FBI has policies and procedures for when they do and when they will not tape, and this is obviously one of those situations that they would not have taped, but it's a known risk. If they're not going to tape that interrogation and there's going to be any small inconsistencies, they're going to go after it. And on top of everything else, with the statement, the jury is told that you cannot credit or use a statement against a defendant unless you first find that it was voluntary. And so by not taping it, jurors are immediately going to question, well, was it voluntary? Was she, now that there's any allegation in this case, was she tortured first? Was she subjected to some coercive interrogation? Was she denied food? Was she denied a cigarette? And so by not videotaping it, that voluntariness, which is the threshold issue, the issue that you have to first decide, that comes into play when it really, like you said, it shouldn't be.
Well, I tell you, talk about the system, Brian Wagner. Certainly the acquittal, devastating to the families. No justice served. Many thinking here. You wonder the message it sends to the rest of the world. Listen, maybe it's okay to do things like this. You wonder about the system in general, but, the bottom line, that's why we go to trial on this stuff, huh?
Yeah, and it's funny. I would actually take the opposite view. In this particular case, there's no guilt by association here. Her husband was a terrible guy, and she probably knew that her husband was up to something terrible, but that doesn't make her a criminal. She had to do something that would have actually been some sort of criminal act. And in this case, the prosecution didn't prove that, and as a person who's been in criminal law for so many years, you have to respect that and move on and hope that the system works better and it learns from its mistakes.
Indeed. Very interesting stuff coming out Friday. Brian Wagner, can't thank you enough, criminal defense attorney, founder of Wagner Law Associates, based in the city, also a former senior prosecutor for the DA's office out of Brooklyn. Hopefully we'll get you back on for others. Brian, a pleasure. Thanks again.
Thank you so much for having me.
There you go. 8:21 on this.